All right. Okay, ready? So we're what, group two? All right, we got chapter three. So it's students, the law in public schools. I'm Dion. Right, so we're with Bridget and Brooklyn. All right, so our chapter is about like school officials. So it says school officials are granted broad powers that establish rules and regulations governing the student conduct and the school setting. These powers aren't absolute. One thing the book talks about is something called in loco parentis, I think is what it's called. So it just means in place of the parents. So when students come into the school, basically it just gives officials a reasonable degree of control over students when they're under their supervision. But like it says, these aren't absolute, and there are some rules that limit what schools can have power over and like what they're able to do with students. So as I talked about, it said that they're subject to a standard of reasonableness. So generally rules that are deemed to be reasonable if they are necessary to maintain an orderly and peaceful school environment and advance educational processes. So students enjoy many of the same constitutional rights as adults. The courts have been very diligent in ensuring that these constitutional rights are protected. So just like adults, students have civil rights and they can't be denied these civil rights. There are some times when you are able to deny students their civil rights, but it has to be necessary and justifiable. One of the other ways is if what their actions are infringing on the rights of another person, then you are able to deny them of their civil rights in that situation. But it has to be documented, and there has to be it has to be necessary to protect the rights of other kids as well. So one of the court cases was the Tinker case. So as the U.S. Supreme Court for the first time held that students possess the same constitutional rights as adults, and these rights do not end at the schoolhouse door. So essentially, they have these rights and they are protected even when they come to school. Just because they are under your supervision, it doesn't mean that they still don't have these rights and they're not protected under the Constitution. So one thing the book talked about was some protests and demonstrations. So protests and demonstrations are considered forms of free expression. Students are afforded these rights to participate in these activities, but as long as these activities are peaceful and they do not violate school rules as a result, or result in destruction of school property, they cannot be disallowed. So basically what they're saying is if you know that it will cause material or substantial disruption, then you can stop it. But the court also found that school officials have to tolerate minor disruptions. So if it's not anything that is going to cause serious damage, you have to put up with it to ensure that you're not allowing these students or you're not stopping these students of their freedom of speech and not allowing them to have their rights. One of the things it talked about that included with that was school-sponsored newspapers. So courts generally hold that a school publication has a responsibility for providing a forum for students to express their ideas and views on a variety of topics of interest to the school community. So one thing that it talked about with these school papers was that there should always be a faculty advisor that monitors the material that is written and published. The faculty advisor cannot get in trouble though for anything that is printed that is constitutionally protected material. Even if teachers or professors don't like what is being said, they still cannot be held responsible for anything that is published. Schools can't suppress students' freedom of speech either. So as long as it's, like I said before, it's constitutionally protected, they can say what they want. Some things though that they can't do, the materials can't be libelous, vulgar, obscene, or mock others based on the race, origin, sex, color, or religion, or anything like that. So there are some things that they are not allowed to publish, but for the most part, students should be able to express their opinions. It says while the newspaper is intended to represent a forum for student expression, those responsibilities for this production should be mindful of the obligation to embrace responsibilities of journalism. So one thing that talked about was that school newspapers that are part of the curriculum, if they're doing it for a class, they're not necessarily provided the same privileges that are published to, or that are provided to published newspapers, that are outside of the curriculum. So school officials are able to regulate that content a little bit more, and they can decide that they're not going to publish something that isn't consistent with the educational mission of the school because they are doing it within the curriculum. So it's a little bit different than if it's a newspaper that is not inside the curriculum. Another thing that talks about was censorship. So broad censorship by school officials isn't permitted and is a violation of freedom of speech rights for those students as well. It does talk about limited review of school sponsored publications. That is permitted, but broad censorship is not. So it's important that school officials don't try to abuse the limited review policy. They cannot use the limited review process either to suppress or limit a student's right to a freedom of speech. So basically what they're saying is they can't say that they're going to review something for publication and it takes a year just so that these kids aren't able to publish what they want to publish. So it has to be in a reasonable amount of time, and there has to be a process that they go through, and there has to be a reason that they are reviewing what is going to be published, and they have to allow them their rights of freedom of speech.
Okay, so speaking on censorship, in that same general topic of censorship and what the students' rights are, they'll have their school newspapers that Dion talked about, but then there can also be a non-school sponsored newspaper. So I was a little confused what a non-school sponsored newspaper is. It's kind of like an underground newspaper. It's something the students are doing away from school on their own time, on their own dime. It's not being published at school. And it's just something the kids are doing on their own. This is still protected. It's still part of their freedom of speech. So as an administrator, we're not allowed to tell them they're not able to have their own newspapers, even when they're not part of a school function. So school officials cannot just completely ban them from having these quote unquote underground newspapers. As a guide to that non-school sponsored newspaper, there are restrictions, however, about where the students can release those publications. So in terms of time and place. So there are conditions to their freedom of press, but it doesn't stop them. So there's a couple of guidelines for this for us as administrators. Defensible policy should be developed that cover all aspects of student publication. So hopefully as an administration, the school has a policy regarding all of these things that would help support any actions we would have to take as administrators. They should be very carefully crafted, and I would highly recommend that they probably would go through your legal team to make sure that that is a legal policy that you are creating. Also should go through the students and the community and the parents so that it is deemed as being fair. The policy should be very specific, and they would have to provide proof. Okay, so students are responsible for producing those newspapers, are held accountable for any libelous material. So just like the in-school newspaper that Dion talked about, these out-of-school newspapers or anything that they're writing outside of school, they do have the accountability of not doing anything libelous, or they can be in legal trouble themselves. There are a couple other notes there. If they do distribute that time and place, if they do distribute these newspapers, underground newspapers at school, The students are responsible and required to remove any debris. So if they were handing them out and people were tossing them in the air, it would be the student's responsibility for cleaning that up. They have the right to distribute it as long as it doesn't interfere with normal school activities or cause a disruption, very similar to what Dion said about the in-school newspapers. The school would assume no responsibilities. So they're not responsible for assisting in any way, and the school is not liable for the content. That would be on the students themselves. So there was a couple of landmark court cases regarding these non-school newspapers. The first one that was in our book was actually kind of interesting to me because it was a school district that I went to kindergarten in. So when I saw the name of it, it was a school I recognized. So that was kind of fun. The case was Bystrom versus Fridley High School Independent School District. This is in the 8th Circuit Court of Appeals, which is our district. I'm assuming that this is the Fridley in Minnesota, and that's where I'm from. So I think it was interesting. That case supported a school rule that prohibited the publication of having pervasive, indecent, and vulgar language. So students are not allowed to be vulgar or indecent in any of these newspapers. And then there was also one in the 9th Circuit, Birch versus Barker, where there was a school rule that was too broad. So like I said earlier, if you're going to have a school policy regarding these, they need to be very specific, because there was a court case that went all the way through to the 9th Circuit, and their school rules were too broad and vague prior to distribution. So all of these lawsuits need to be policies need to be written specifically. Okay, so about student rights, the next section in our chapter was about the rights students have when it comes to their dress and their appearance. Student dress is also a form of free expression and a form of self-expression. And it is not viewed as significantly as most other forms of free expression. So obviously your right of free speech is a very strong and powerful right. Dress and appearance doesn't get as much weight in court as speech does. The self-expression is a way for students to show off their values, their background, their culture, and parts of their personality. So it is part of their First Amendment rights of freedom. When this has gone through the courts in the past, it's something that the Supreme Court has consistently declined to have brought before them. The Supreme Court does not hear cases based on dress and appearance being a First Amendment right. So this is usually left to individual state courts. Dress may be regulated at school if there is a defensible basis for doing so. So as administrators, we can't reprimand students based on fashion or taste just because we may not like it. That would be violating their rights. However, school regulations that violate students' rights by being vague, ambiguous, failing to demonstrate a connection to disruption will not meet court scrutiny. So again, when you go back to writing school policies, they need to be very specific. As far as this dress and stuff goes, it goes back to what Dion said at the very beginning. All of these rights come down to being an emphasis on reasonableness. So were people being reasonable in what they were asking students to do? And we have to constantly remember that, number one, students have these rights, and you always have to weigh the rights of these students versus restricting rights. So their own personal rights will most likely trump restricting their rights. There are a couple of ideas here too when it comes to what we can do as administrators. Local school dress codes can be developed by the school. They should be always approved by your Board of Education. Faculty, students, parents, and citizens should all be involved if they're going to come up with a dress code of the school. And then all of this should be communicated and discussed with students and parents. Okay, so then you get to specific things like controversial slogans. So if you have t-shirts, caps, and other things that are in direct conflict with the school's state admission, those things can be regulated. And again, like Dion said, it can't be vulgar, lewd, or obscene. There are some case law that goes with this. The U.S. District of Court in Massachusetts had a case, Pyle versus the South Hadley School Committee. They had something with a t-shirt and a band. And a couple of the t-shirts had some interesting language on them. One of the t-shirts said co-ed naked band, and another t-shirt said do it to the rhythm, like on the other side of it. Another shirt said see dick drink, see dick die, don't be a dick. So because there was some language used that was kind of come out as being vulgar, that went to the court, and in that case the court did side with the school. Banning those slogans was upheld for foul language. There was another case, Scott versus the School Board of Alachua County. There were students that had, and I'm guessing Alachua County might be down south, the way that this was written. It was in the 11th Circuit. So I think that's one of the circuits towards the south end of our country. Student had a Confederate flag. So the school banned Confederate flags, and that banning was also upheld, because when it got to that court, they decided that they were right to ban it on two grounds. One was it was a disruption to the school, and second, it could have been offensive to some. So some people saw it as a sign of Southern heritage, but the other side saw it as a sign of slavery. So the court did decide that it could be offending students, and so they were being hurt at school, and that was not to be allowed. So there are a couple of ideas to use as guidelines there if you're going to be restricting student dress. One that will always be upheld is if it's for safety. So if it's a science classroom and that science teacher has restrictions on long hair or something that would be unsafe during a lab situation, student safety is always going to trump their self-expression. The second one would be an issue of health and keeping the general population safe. So there have been instances where students were asked to keep their hair clean and maybe short to prevent head lice running through a school. The third one is community standards. So all of these dress things, they leave it up to the states, because every state might have their own specific community of what they deem being reasonable. And so you have to go with the community standard of that particular school. So is the student calling attention to certain parts of their anatomy? And is that okay, or is that not okay with the community? That's what the court's going to look at. And then the last one is it going to cause a disruption? Is it vulgar, lewd? Does it have language based on race, color, gender, nationality, or religion? Those are never going to be allowed. Okay, then when we get to the next section in this chapter, it's regarding student rights and consequences that can happen. So the first one that they had was school suspensions. It is a legal form of discipline for students who violate school policies. In-school suspensions are used 91% of the school districts in the United States. Out-of-school suspensions are used by 95% of the districts. Usually a school suspension is going to involve an issue of safety to the other students. My notes on that. Sorry, hold on. Okay. Was there adequate notice provided to the students and parents regarding the existence of these rules? Like, as far as student behavior goes, is there a clearly communicated rule? And there should be a record that has been compiled with this information of why a student was suspended. Was the infraction allegedly, what was the infraction? What was the time, what was the place, who were the people involved? And were there efforts made to remedy this behavior in the past? So all of those things would need to be considered. Okay, so then we get into a student's rights to due process. So there are two kinds of due process. There is procedural and substantive. Procedural due process means that if a person is to be deprived of life, liberty, or property, there is a constitutional procedure to follow. Substantive due process ensures that a valid reason exists if a person is deprived of life, liberty, and property. And it wasn't reasonable. So, essentially what they're going to get down to is, was their due process, were they treated fairly? Due process has to do with whether people receive a fair hearing, a free trial, and a fair judgment. We do have a North Carolina Court of Appeals case that went all the way to the Supreme Court for this. A student was being accused of sexual harassment. And when the administration pulled them in, they deprived that student of an attorney being present, and the Supreme Court ruled that their due process entitled that student to an attorney, and so the school lost their appeal.
All right, expulsion. So unlike suspension, expulsion is considered one of the most severe forms of discipline because it involves a long-term separation from the school district. And then in some instances, it could even be that permanent separation. Because expulsion deprives a student of the right to attend school, a formal hearing must be held so that the student is afforded their 14th Amendment rights involving due process. Searches may be conducted by school personnel if reasonable suspicion is established. Reasonable suspicion is based on the information received from students or teachers that is considered reliable by school officials. School officials do not need a warrant for searches. Once we get into law enforcement does need those warrants. Personal searches. There should be a sense of urgency based on a belief that the student has in his or her possession some dangerous item that could pose a threat to either themselves or others in the school. Personal searches must be about a current situation. So in the Owensboro Public Schools, they had a situation involving a student that was thinking about suicide. And so after talking to different teachers and seeing, trying to figure out what was behind the scenes there, his phone was searched. And they found indication that he was thinking about suicide. He ended up going to treatment for 1 to 2 weeks, and the district was not in trouble for searching the phone as there was specific concern that there was a need to help this student. However, 6 months later, the student was on his phone in class and the teacher confiscated his phone and turned it into the principal. The principal then decided to read some messages to see if he was still leading to hurt himself and commit suicide. Because he was just on his phone and there was no potential harm when he was on his phone in class, the district was found in violation and lost the second time around because there was no thoughts of him hurting himself. He was just on his phone in class. Law enforcement. When law enforcement officials enter the school, they do have to have that warrant. If a warrant is issued, strong evidence involving probable cause should be established. Reasonable suspicion does not apply here. Prior to a search, parents or legal guardians should be contacted and may choose to be present if they would like. If they don't want to be present, or if you can't get a hold of the parents, then a school official can accompany that student as that witness. Metal detectors, the use of metal detectors, like other intrusive methods, must be justified as reasonable and necessary to meet a legitimate school objective. Maintaining a safe and orderly school environment was considered a legitimate school objective. Corporal punishment usually involves the use of physical contact for disciplinary purposes. As it is used as disciplinary tool, it is not uncommon within school systems in the United States. The Ingram versus Wright is an example of corporal punishment. The student received 20 licks while held over a table for violating a teacher's instructions. Medical attention was required and the student missed several days of school. The High Court found no constitutional violation. And according to Essex, a recent survey conducted by the National Center for the Study of Corporal Punishment and Alternatives in School states that at least 2 million US students are physically punished each year, and 19 US states still allow this type of punishment to happen. Classroom harassment is a form of sexual discrimination based on the US Supreme Court's ruling in Davis versus Monroe County Board of Education. The school officials are reliable if they are clearly unreasonable and deliberately indifferent toward the alleged harassing conduct. And then the last part is pregnant and married students. So the courts have generally held that pregnant and married students may not be denied the opportunity to attend school. The basis for court's position is that these students must be allowed the equal protection under the law as well as due process of law. Married students are emancipated, so they can't be forced to attend public school. However, if they would like to attend public school, they must be allowed. Their wish cannot be denied opportunities for extracurricular activities or any kind of education there. Married students do have the right to attend public schools. Any rules designed to exclude them from attending schools are invalid and in violation of their 14th Amendment rights, namely equal protection under the law.
That's it.
That's all of chapter 3.